Hello, everyone. My name is Wendy McClung. I'm Vice President at Baxter Travel Media, but today I have a new role, that of one of the company's anti-spam officers. I know it sounds exciting, but there really isn't any salary attached to it, but the job comes with a big responsibility. And I'm hoping that by the end of this session, you will either jump at the chance to take this on yourself or volunteer others in your organization. So, welcome to today's Travel Law webinar. This is the second webinar in a week we've hosted due to an absolutely sold out first session, and now this one is as well. That's how important this new legislation is to us all and shows the keen interest you have in what our experts have to say. Baxter Travel Media has been a leader in anti-spam resolution since 2003 and is in favor of stricter regulations to protect everyone's best interest. Our responsibility to you, our readers, is to ensure we're delivering the news and information you need to run profitable businesses and maintain successful careers. Today you will gain a better understanding of the legislation and take this information back to your colleagues to develop CASL implementation strategies for your workplaces. Please feel free to ask questions in the box provided as we go along. In the coming months, make sure you're subscribed to our news outlets, Canadian Travel Press, Travel Courier, Press Today, and TravelPress.com, as we help prepare the industry for the impacts of the CASL. And make sure you check out Travel Watch's new Travel Agent Toolkit that will help you attain compliance. All relevant web and email addresses will be provided to you at the end or perhaps later on when we send the Q&A, the questions and answers to you in a separate email. And now I'll turn it over to the real experts, Doug Crozier and Tim Law of Heifetz Crozier Law, whose monthly column appears in Canadian Travel Press.
Thank you, Wendy. This is Doug Crozier starting off. Tim will follow in a moment. Good day, everyone. If you registered for today's webinar as a result of an email that you received about it, that sort of email might suddenly become an illegal communication if it was sent after July the 2nd of this year. Tim and I are here to introduce you to some of the highlights of Canada's anti-spam legislation, the acronym for which is CASL, C-A-S-L. We'll be referring to CASL during the course of the hour. In order to give you this introduction, we want to provide at the outset some context for where CASL came from and why it exists. It seems as though in both the trade and the consumer press, CASL has come out of nowhere in recent weeks. In fact, it's got a lengthy history. The legislative process, and this is federal legislation that applies from coast to coast, the legislative process started about a decade ago. The legislation itself was passed but not put into force in 2010. So it's been around for a while, and as you know, with all laws, the legislation is the skeleton, and then there are regulations that fill in the flesh on the skeleton. I'm suggesting that the legislation itself has been around since 2010. As far as the regulations are concerned, the drafts of those regulations that put the meat on the bones of the skeleton that is the legislation have to be finalized before the whole process can be put into effect. Drafts of those regulations were circulated to the public in the summer of 2011 with an invitation to respond and comment. There was a fair bit of feedback, and as a result, some changes were made in the regulations. Gradually, they've been finalized and now effected. It was in December of 2013 that it was announced that July 1, Canada Day of 2014, would be day one for this brave new world. The CASL legislation exists because governments throughout many of the developed countries, not just in Canada, have recognized the need to regulate some of the less positive aspects of the new technology that all of us have embraced. It's not a Canada-only initiative. That said, commentators that are familiar with what other jurisdictions have done in the area are almost unanimous in saying that the Canadian version is the most aggressive or the most strict, sets the highest bar of all the ones that have been implemented around the world. So why are governments taking these steps? That's the fundamental question to ask. Law school students everywhere get taught early on that in order to better understand legislation and regulations, you have to identify what the problem is that is being targeted. Legislatures don't just pass laws for the fun of it. They pass laws because there's a perceived problem. And so part of your ability to understand how the process works is to identify what they're trying to solve and then be able to identify whether the legislation with the regulations are doing a job of solving it. The principle with which CASEL started is pretty simply stated. It's 3 words. Spam is bad. Once you accept that principle, the corollary is anything that reduces spam is good. Now, you're going to get pretty well universal approval for those 2 statements, but as we all know, the devil's in the details. And what started out as a simply stated pair of principles, spam is bad and anything that reduces spam is good, has evolved into a regime, this CASEL regime, that involves the legislation itself, regulations passed by the CRTC, which is one of the regulatory bodies that's involved, Canadian Radio, Television and Telecommunications Commission. There's regulations from Industry Canada. The CRTC has set out 2 guidelines on the interpretation of their regulations. There's an FAQ from the CRTC, and there's 1 and perhaps 2 more expected to follow as we approach the 1st of July. And there's also a regulatory impact analysis statement that in a non-binding way seeks to explain what the other pieces are intended to accomplish. So there's a fair amount of material that has to be reviewed and digested and understood in order truly to be a master of the CASEL legislation. In the time we have today, we're not going to try to get into specific detail, but rather to give a high-level introduction to the key elements of CASEL. In terms of the format, we do have in the slides that you'll be seeing some practical information that we do want to relay to you, but we also expect that you're going to have some practical questions of us, and we hope that we can answer those questions, most if not all. I say hope to because at this point we have no actual experience. July 1, 2014 hasn't yet come. All we can do is answer based upon what we believe or expect is going to happen because we have no practical experience under our belts, nor does anyone. The analogy that I used in the earlier session on the 1st of May was that we're sort of like Christopher Columbus or Neil Armstrong, loaded down with all sorts of theory as to what's going to happen when you cross the ocean or land on the moon. But that theoretical information is going to have to bend under the practical realities when the 1st of July comes. But until then, we'll do our best to answer your questions and to give you that high-level overview that I referred to. To get things underway in terms of specifics, Tim Law will now take over.
Thank you, Doug. Thank you, Wendy. Thank you, Baxter, and good afternoon, everybody. Let's begin with what is our second slide, but the first one of the points that we've put together. Doug had mentioned that CASEL is a federal law regulating sending of commercial electronic messages. That means it will apply all across Canada, and in fact, this is one of the issues that's come up. It applies with respect to any computer that receives a message if it is located in Canada, or one that sends a message if it is located in Canada. So it's a fairly broad piece of legislation. As Doug said, it comes into effect on July the 1st in relation to these commercial electronic messages, CEMs as we will refer to them this afternoon. It then comes into effect a little bit later on at the beginning of next year, January 15, in relation to the installation of computer programs. And lastly, on July the 1st, 3 years hence, in relation to a private claim. That's a claim that could be made by an individual against another individual as a result of some harm that is caused by the sending of a CEM. So what is a CEM? Well, it's a very broad description that you put together by reading through the legislation. An electronic message that is of a commercial character, whether or not it's sent in the expectation of profit. What we know that it does include are messages promoting a product, a business or an investment opportunity, messages sent by means of telecommunication, and that includes email accounts, the instant messaging, telephone accounts, and other similar electronic methods of sending a message. It also includes text, sound, or voice messages.
So, on or after the 1st of July, if you want to send a CEM, you need the consent of the recipient. And as Tim said, a CEM is pretty well any electronic messages that involves a commercial activity, whether you expect to profit from it financially or not. If it deals with a commercial component, it's a CEM, and after the 1st of July, the recipient has to have consented before you can send it. That consent can either be express or implied. We'll develop both of those concepts in a moment. The onus is on you, if you're the sender, to be able to prove that you have either express or implied consent. If anybody ever asks, the onus is on you to prove, and if you can't satisfy that onus, the assumption will be that you've sent a CEM without consent, which would be a violation of the legislation. The irony is that if you, after July the 1st, send electronically a request for consent, that is itself a CEM that violates the Act. So that's why you're seeing a flurry of activity now that people are grasping onto the significance of this legislation. There's a flurry of activity. You're probably receiving, as we are, a lot of requests for consent. Some of them are expressly relating to CASL, saying because of CASL we need you to consent. Others are, I don't want to say masked, but they don't refer to CASL. They just say, we want to update our records. Could you please confirm, bing, 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 bing. The whole purpose of either approach is to get in your hip pocket before the 1st of July consent. Whether you go with express or implied consent, the recipient can withdraw it at any time, and that too will be something we'll be developing on a future slide. So the onus is on you to get consent, and that consent can be withdrawn at any time.
So now that we've told you that it's all-encompassing and applies to all sorts of things, we have, of course, dug out the things that it doesn't apply to help as you move forward and try and navigate the new world after Canada Day. What doesn't it apply to? You won't be surprised to see that in the first point it doesn't apply to communication between individuals with a personal or family relationship, and likely fairly similar is the fact that employees in the same organization can also send and receive that which would be a CEM without running afoul of the Act. Moving down to the third point, the messages sent by a representative of an organization, and we put a note in there to say that the concept of organization is not defined. It seems to be differently referred to throughout the law. But if they're concerning matters of the organization and they're being sent to someone in the organization, CEMs won't be a problem there either. Here's a very important one, and this will help you post-July 1st. You won't have a problem if the message you send is in response to a request, an inquiry, or a complaint, or if the message was somehow otherwise solicited by the person to whom you're sending the message. Dorothy, ding, 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 you win the prize for being the first brave question asker. If I've done business with a client, in other words, provided travel services, may I assume implied consent and send him my newsletter? You may assume implied consent, and hopefully you have that implied consent because the provision of travel services occurred within 2 years of July 1st. If you have that kind of implied consent, you're grandfathered in under the law for 3 years. Important to remember, though, every time you send an email after July 1st, you must indicate in it who it is that's sending it, likely to be your agency, and you must also include an easy unsubscribe mechanism. If you don't have that business relationship, as it's referred to, by July the 1st, but you've provided services, you will still have a 2-year period, as long as the person doesn't withdraw consent, during which time you can send your newsletter. Fourth point on the slide, messages sent in regard to a legal obligation. That's likely to concern us more than it does you. Last one, messages that complete or confirm a commercial transaction already entered into with the recipient. So you're simply sending out the travel documentation after the person has purchased the services. Flipping over to the next slide, you'll see also excluded are those that provide messages that provide safety, warranty or recall information about the goods and services that the person has purchased from you. The next point, the interactive two-way voice communication. There's your telephone call. You don't have consent on July 1st. You can still get on the telephone and seek that person's consent. Faxes sent to a telephone account. There's the ability to send the faxes afterwards. A voice message if you don't get the person on the phone. Those are other ways that you can acceptably try and communicate. Messages sent on behalf of a charity or political party or organization. And lastly, messages sent and received where the necessary information and unsubscribe option appear in the system itself. We've given you the examples there of Twitter, LinkedIn and Facebook. Those systems have a buy-in or a consent piece up front when you sign up and when you choose to interact within the systems.
We're going to start with implied consent of the two. There's implied and express consent. There's a couple of ways of getting implied consent. The first is where the person that you ultimately send your CEM to has conspicuously published his or her email address, like on a business card or on an advertisement, or has disclosed it to you. So basically the idea there, and this is only the first half of the criteria, the idea is that if somebody is making known his or her email address, then it's legitimate for you to pick up on that and to say, here's my CEM. That, however, is sort of narrowed down by the fact that the recipient must not have said to you, here's my business card, but please don't send me any junk. If they've said they want it narrowed down, then you can't assume that just because they published it that they're fair game. And as well, the CEM has to be relevant to their business. A second way for the implied consent to come is if you've got an existing business or non-business relationship. We don't intend to spend time today talking about non-business relationships. That usually involves volunteering and charities and that sort of stuff that's not relevant to today's audience. We are going to talk about what is an existing business relationship.
So then, you have an existing business relationship if you have that which is on the left side or the right side of the slide. In other words, the recipient of the CEM has purchased, leased, bartered a good or service from you in the previous 2 years. You then have the implied consent, which will expire 2 years after that purchase or lease or barter was made, or if the person tells you they no longer wish you to send anything to them and withdraws the consent. The flip side, or the other side of that, is if the recipient has made an inquiry of you about a product or service in the last 6 months. Similarly, you have in that case the implied consent, but it will expire under the Act after 6 months, or, in the same way as the 2 years, if the person tells you previously that they no longer wish to receive email. I see we have some questions. Okay, so let me just, sorry, okay. If I've done business with a client, no, we have that one. Automated marketing systems have built-in opt-in. Is this the same as Facebook? Frankly, I'm not exactly sure what you mean about automated marketing systems having opt-in. What's important to remember about the ability to get consent is that it is an opt-in process under this legislation. In other words, I have to ask you to actively check a box or put an X in a circle in order to get that. I'm not so sure that answers your question, though. Scott says, I print for many groups and I email to their members on behalf of them. So if I have the group's permission and they have permission from their members, am I okay? Well, you would want to know that they did in fact have that permission. That's the crucial thing there, Scott, and we'll talk a bit later about this concept of a due diligence defense. If you were diligent in making sure that you had consent, you would be okay, but you do need to make sure that you've got the individual person's consent with respect to each, assuming you're using email address.
The bottom line of that is just because the organization says it's okay, you can send it to these 100 or 500 people, may not be sufficient. You may have to make inquiries to make sure that the 100 or the 500 have given consent, if not to you, Scott, at least to the organization on whose behalf you're doing the dissemination.
Julie, you say you meant if it's published on the website. Yes, so for example, if you went to our website and you found my email address, there it is, it's published. There's nothing on the website or on the particular page about me that says, don't send me any CEMs. You would then be in a position to send me CEMs if you believed that my role at the law firm involved whatever product you were sending me, in this case, travel. Is there a print version of this webinar? It's going to be emailed out to you, Sharon, in PowerPoint format, I understand. 2 years after purchase literally means that, Lana, it will be 2 years after the purchase, not the date of the travel or the departure or return. Thank you. Well, those are easy questions to answer. Okay, let's go to the next slide to make sure we keep up.
I don't think we finished the 6 months for the inquiry.
Oh, is that so?
Yeah.
All right, let's make sure that we get that. So just to reiterate then, or to iterate, the secondary way in which one can have the implied consent, and it's important to remember that this implied consent can exist after July the 1st, and that is if the product or service has been inquired about, and you then send your email to that person within 6 months. They inquire of you as of July the 21st. As long as you send the email back to them within 6 months, you have their implied consent to send them an email about that which they inquired after, not just any kind of email.
And one of the points that we're going to be trying to get across today is the need for you to document these dates. Your back office automation, or you may even just be doing it by hand, you're going to have to be able to track when the 2 years is up from the actual purchase or the 6 months is up from an inquiry. It's not going to necessarily be an easy thing to do, and one of the points we want to convey to you today is that you should be thinking now about it, because the 1st of July will be upon us very quickly. We'd said that there was 2 types of consent that you needed from the recipient, and Tim has explored the implied consent. The express consent is the best type of consent. You are all, as travel counselors, taught, trained, urged to convert the inquiry from a potential customer into a sale. I know a lot of you live by that whole idea that your job is to convert questions into sales. To the extent that you can, you're going to want to also convert implied consent into express consent. That's because it never expires. You don't have to worry about 2 years and 6 months and diarizing or anything like that. Express consent is money in the bank, subject to the fact that it can be withdrawn at any time. Any recipient could say, look, that's it, cut me off. And you've got to honor that, as we'll explore in a moment. But express consent is the coin of the realm if you can get it and be able to prove it, which is the second bullet. That's what you're looking for. The one other caveat, which is the third bullet, is that express consent has to relate to the necessary information. Tim's made the point that a person can consent to receiving information about one type of product, but that doesn't expose him or her to receiving information by CEM with respect to other types of product. A consumer can say to you, I'm interested in your golf products, send me only golf-related stuff. And that's a legitimate position for him or her to take. That doesn't justify you sending cruise information or Indonesian information or anything that doesn't relate to golf. So the third bullet that we have on that page that talks about the necessary information is your need to be able to prove what the person has consented to receive.
Let's just deal with your question, Stuart. Does the email being listed on a website, or effectively any website, for example, in a job posting or information that the person has a new position, is that the same, is the question? And the answer to that would be, I think you can assume so. The law says if the person has conspicuously published or has caused to be published. Now, in your example, perhaps the individual didn't actually cause it to be published, but I think it's safe to assume that the publisher got the consent of the person in order to put their email address on it. You still have to come back to, though, and this will make your job more challenging, I suggest, if you find someone's email address in a publication, that doesn't necessarily mean that the kind of email you're sending to them is relevant to their role in this new job. The example that we've given in the past is if you are sending an email, if you're a travel management company and you're sending an email to someone you know looks after travel for all 20 of the executives at the company in Toronto, that's one thing. But if from that same website you're able to gather the accounting department's email addresses or the HR department's email addresses, it's safe to say you can't assume that part of their job or part of the role of their job is the booking of travel. So you have to be careful about that.
I can take advantage of Dorothy's question to complete the section on express consent. And I'll answer your question, Dorothy, in the context of this next slide. As I'd said at the last one, you've got to ensure that your request is clearly identified and not bundled. Oftentimes, terms and conditions can run to a number of pages. None of us really read terms and conditions before we click OK and proceed. The temptation would be to put in those terms and conditions for the use of your website, for example, to insert into them language that will comply with CASL. But CASL says, no, you can't do that. Your request for consent, for express consent, has to be specific and isolated from other stuff. Can't be hidden. And in answer specifically to Dorothy's question, the second bullet, it has to be an opt-in. You may recall the trouble that Rogers got into about 5 years ago with the negative option, where they were sending out letters, emails, I don't recall which, saying unless we hear from you to the contrary within the next 30 days, we're going to assume you've accepted da-da-da-da-da-da. And Rogers got into a lot of difficulty. So will you if you try to rely upon that negative option. So if you send out anything that already has the I agree box checked, that puts the onus on the recipient to uncheck it before saying I agree, and that's not good. You've got to send it out without the box checked, saying if you do want to receive CEMs, you must overtly, Mr. Recipient, Ms. Recipient, check this box. There has to be in any consent protocol the purpose for the CEMs. That's the whole idea about golf as opposed to cruising that I mentioned earlier. There has to be information about the organization that's seeking the consent. It can't just be done anonymously. There has to be contact information, addresses, and so forth that are set forth so the consumer can know to whom he is giving the consent, and that contact data has to be valid for the next following 60 days. As a result, any of you that are going to, after July 1st, be in the process of moving, you're going to have to think ahead and make sure that your websites take into account 60 days worth of data. It strikes me as though you're going to have to, for a period of time, run a pair of contact coordinates. So you're saying up until January 1, 2016, these are the coordinates, and after January 1, those are the coordinates. And the last thing on this bullet, last bullet on this page, talks about the fact that a recipient can always unsubscribe. You've got to give him the option to do so on every one of your CEMs so that there's an easy process by which he can bail.
Okay, Michelle, can we ask for express consent for all types of communication, for any travel-related communication from me? Yes is the short answer to that. And to use an extreme to make a point, you can also ask, does the person want any information on the sale of puppy dogs? If you ask, you can then send. Whether that's a good marketing strategy, we'll leave for you to decide. Stefan, so buying opt-in email lists is illegal. Oh, I see. Buying, all right, we'll assume that you mean buying a list on which, or in which people have already opted in. Well, if they've already opted in and you're going to send them that information, all you're going to have to do is tell them it's now XYZ as opposed to ABC that is now sending you the information. You will still have to, in addition to the identification information, say, and by the way, and this has to be in every one you send, if you no longer wish to receive this email, click here, reply I don't want it. It has to exist in everything that you send subsequently.
And the other thing you're going to have to be aware of is, did the person whose email you've bought consent to what you're going to sell or send them? Opt-in list, it's not illegal to buy a list or to use a list, but if you do use a list of email addresses, how are you going to be able to prove that the person has asked for cruise information as opposed to golf information, as opposed to adventure holiday information? So I think there's a very real risk inherent in just buying an email list and sending stuff out to people on that list, because I don't think you're going to be able to prove what they've consented to receive.
And part of your due diligence in making that purchase would be to have your lawyer or yourself confirm exactly what it was you were buying, along with the proof in relation to every single email address, what it is you have consent for. Tammy, most of them want to deal with email. You receive an email from them. Are you okay to carry on? You're okay to carry on if what they've done is made an inquiry and you're simply responding to the inquiry. If they come back and they say, oh, thank you, could you clarify X? Absolutely, carry on. You can keep going back, as long as it's within 6 months, responding to the inquiry. Peter, does unless I hear from you otherwise constitute implied consent? No, it doesn't, Peter, but nice try. Lena, what happens if I change my email address and forward you're advising the people? I think that would very definitely still constitute a CEM because you're doing it for a commercial purpose. In other words, you're letting me know my new email address is over here, so you would have to comply. Stefan, yes? Okay. Sending a business proposal to another business. You would have to have their consent, Stefan. Excuse me. Because if it's a business proposal, it is most certainly in. I was paying attention, but not for long. Did I miss how we get an opt-out link in our email? A couple of ways that you can do it. One way is to say, hit reply and tell me you don't want this anymore. And most people, though, you'll find have the link in there and sends the person over to a website. You need to have that website reference as well.
Let me take us, we finished that one, so we're going to go to the transitional period. There's a bit of good news. You may have heard from Tim and I things that you have characterized as bad news up to this point. A little bit of good news is that there is a 3-year transitional period that we're looking at. If you have an existing business relationship on this coming Canada Day, and business relationship, you'll recall, means the purchase of a product within the 2 years prior, so that takes us back to Canada Day of 2012, and you've sent a CEM to the person previously, then that implied consent is assumed to exist for the next following 3 years. So that's a big relief, I'm sure, and it gives you a 3-year period during which you can try to convert, going back to a comment I made earlier, convert that implied consent into express consent. Second bullet talks about that 3-year transition period. Of course, it's until it's withdrawn. just you don't have the ability to have a full 3-year period. If the recipient says, I'm out, you've got to honor that, even though the 3-year period is still current. For business relationships that were created after this Coming Canada Day, the 6 months for inquiries and 2 years for purchases that we'd referred to earlier apply. And the last bullet was due to the nature of the implied consent and the transition clause. It's important to keep track of the dates that back office.
Okay, so what is all of this required content that we keep talking about? We say you have to have the person's consent, we say there are things that have to go in it, and we say there's unsubscribe mechanisms. Let's focus for a moment on the required content that has to be in there. You have to put in this CEM, the name of the organization that's sending the message, along with the contact information, your address or a P.O. box, phone number, an email or website address, and there's that point that it has to be good for 60 days that Doug mentioned a few minutes ago. There's also the possibility that these emails may be sent on behalf of someone else. If that's the case, you need to identify in the email as the sender who you are and on whose behalf you're sending the email. That's another important consideration. And you have to have the contact information for at least one or the other. Next point is that the CEM must state that the recipient can unsubscribe. And this mechanism names or sender names in the CEMs that you send out. One other arguable exemption is that if it's an initial CEM being sent, you haven't contacted this person before, based on a referral, you must include the name of the person who refers you. And you'll see at the bottom there, this is also an exemption. If you are given a referral from someone that you know, and someone who knows the person to whom you are sending the CEM.
That's this question.
Ah, okay. Good, all right. Well, then we'll answer your question as well, Lana. You should give her a call. Can we call this person? Well, you can call the person and you'll be okay because that is a call and it's exempt. You could also email the person. You can also email the person, and that is permissible as well if it's a referral. In other words, if it's the first time you've contacted them, you are allowed to do that as long as you indicate it was Jane who told me I should contact you and send you this information.
And you only get one of those. In terms of the unsubscribe mechanism, it must include the ability on the part of the recipient to unsubscribe in the same, with the same electronic means or vehicle by which the message was sent. So you can't, by Facebook, say you've got to go to my website in order to unsubscribe. If you're using Facebook, the unsubscribe process has to be accessible via Facebook. The unsubscribe data has to be valid for 60 days, the same as the contact information that Tim had mentioned. And it can only be a one-step process. You've probably already, in trying to unsubscribe from things that you've been receiving, have seen an unsubscribe box, you've checked on the unsubscribe, and you immediately get a screen or an email that says, are you sure? Please reconsider. We don't want to lose you. Please think again and again. None of those processes are acceptable. It's got to be a one-stop shopping. If the person says, I'm gone, they're gone. And that's the end of it. And you've got a 10 business day curfew on your processing of any requests to unsubscribe. So it's going to have to be something that's done fairly quickly. In terms of the questions, going back to the top of the panel, we had the question from Scott about I'll talk about Scott's in a second. The Assunta Mazzata response about two-way interactive voice communications was in response to an earlier question that has disappeared from the screen. Scott's question related to enforcement, and let me just keep it on the unsubscribe mechanism screen, even though I'm not talking about that issue now. From a practical point of view, Scott, you're probably right. At least until 2017, when the private right of action comes in, there are three government offices, three government bureaucracies that are involved in enforcement. There's the CRTC, there's the Competition Bureau, and there's the Office of the Privacy Commissioner. So there's three federal bodies that are going to be overseeing this. They've signed earlier this year a memorandum of understanding that tries to divide the turf as to who's going to do what, so that they don't step on each other's toes, nor let something fall between them. From a practical point of view, Scott, you're probably right. The government isn't going to bring its guns to bear on a one-off violation by a small mom-and-pop shop. That's not what they're interested in. So don't take that as an endorsement of ignoring CASL, but it is a practical factor that you'll want to take into account. Just like you do when you come to a stop sign at 3 in the morning in a residential area and you decide whether you're going to comply fully with what the stop sign implies or whether you're going to drift. If you drift, you're violating the law, but you're making a calculated decision. The rubber meets the road, however, 3 years from now when private rights of action kick in. And at that point, anybody can go after you for an alleged violation of CASL. And when you take that private right of action into account with the fact that class actions are now pretty prevalent in Canadian society, anyone who violates CASL after 2017 does run the risk of a class action, and they're not pretty, and that's something that I think will up the ante considerably. That's the response to Scott's question. Tim, did you?
Yeah, there's one there from Sandy about clarifying with respect to the business card. Yes, that's an example by which you do have the person's implied consent if they have given you the business card. But as Doug said, if they give it to you and say, don't send me any emails from your travel agency, I'm only giving this to you so that we can go out for dinner, that won't make it acceptable. And the other caveat is that even if they give you the business card and don't tell you not to send them emails, you need to be able to send them information that relates to the role they play at work, not just anything. Sample text for express consent, a couple of places for that. The government websites and also the Travel Watch website will be able to give you examples of that. You'll find those by, you'll see at the bottom Travel Watch's name, but you'll also be able to find those by going on to the government website and getting some examples of what they believe is acceptable. Be aware, excuse me, that what the CRTC says it thinks will comply, or one has to do in order to comply with the law, is no different than what the tax department says you have to do in order to comply with the income tax, or dare I say it, what TICO says you have to do in order to comply with the Travel Industry Act. They're the bodies enforcing the law. You want to listen to what they have to say because they'll give you an idea of when they will and won't come after you if you do certain things, but they aren't the people that can tell you this is what the law says.
I can just jump in on Sharon's question about consumer protection, where she's, I think, suggesting that the consumer protection authorities would be all over this from an enforcement point of view. You run into the constitutional reality there, Sharon, that the consumer protection people are provincial. This is federal legislation, so it's federal bodies that will be enforcing. From a practical point of view, it might be that a provincial consumer protection officer might draw to the attention of their federal counterparts an instance of a violation, but they themselves have no authority to follow up.
Doreen, this is not just for travel. No, it absolutely is not just for travel. And will the face of any e-marketing change? I think that's exactly what the government intends. It's taken its time coming up with this legislation, but it's now decided it'll be the toughest legislation out there. and it simply won't be acceptable to spam people unless they've said, you may send me information in relation to, and guess what? I can withdraw my agreement to let you send me anything whenever I choose to do so. Joanna, it's pretty complicated and time-consuming. Isn't it just? Isn't that what makes it fun? I'm saying that with a big smile on my face, I assure you, Joanna. Yes, there are operations out there. I mentioned earlier on Travel Watch. You'll find them on the web. They're offering the practical services that you may be seeking. They'd be your first stop. When will the provincial people opt in? Oh, well, they won't opt in, but I'm sure they'll comply just for fun. Relevant content. If they travel for business, would it be acceptable to solicit the company account by email if you have implied consent through possession of their business card? Yes, if the person travels for business, an example, you find out some... I'm glad to see we're making you smile, Shan. Yes, if you found out the person's email address from a business card and you think they travel for business, then yes, that would be acceptable. One of their roles is traveling. You happen to provide that service and you can. Be aware that if that person writes back and says, yes, but it's not to me that you should send your emails, please send them over to Jane. She looks after and does a wonderful job for all of us for traveling. But to get going, that wouldn't be a problem. Okay, so let's carry on so we get through all of this.
So we're talking now about some practical steps that you can and perhaps should be doing in the time that remains between now and the 1st of July. It's a question, and we put this specifically as the first bullet, you've got to educate your staff. This is not just an owner-manager matter that can be handled in the back office. Even if you do a very good job of changing your websites and providing for the unsubscribe protocols and changing the words and getting rid of the buried notification out of the terms and conditions, you can do all those things. But if the frontline staff aren't aware of the big picture, you still run a risk because they're the ones that are sending out the CEMs on a day-to-day, hour-to-hour, minute-to-minute basis. So we put as number one the fact that you need to educate within your own office your staff about CASL, at least in a general sense, so that they understand what it covers and how they can inadvertently bring grief to you if they don't have that understanding. You should also be reviewing your various communications electronically in order to understand what ones are going to be exempt and what ones you have to be aware of as falling under CASL. As I mentioned earlier on, you try to get that express consent before the 1st of July because it's still open season. You can hunt without a license until the 1st of July in order to try to bag yourself an express consent. The hunting season gets more restrictive after the 1st of July. The back office protocol, I've mentioned before how that's going to be, I think, an issue. Keeping track of the dates so that you know when implied consent expires. And you're going to want not just to flag when the implied consent expires, 2 years or 6 months after either a purchase or an inquiry, but that's going to be too late in many regards. You're going to want to diarize maybe a month before it expires, or maybe even 2 months before it expires, so you can be ramping up your notifications in order to try to convert that implied consent into express consent. You can also, some people are talking about creating buckets where you categorize data and email according to the type of consent. No consent, express consent, implied consent, opted out. So that you've got a list, either a paper list or a print by way of printout or on your screen, the ability at a moment's notice to take a look at what type of consent you've got.
Let's just deal with our erstwhile colleague has given you a written answer. I was just about to say, thank you, Asunta. I was just about to say, never ask a lawyer for a definition. They'll bore you to death. But there you go. Asunta's put it in for us. That's great. So yes, there is a detailed explanation of what a family person is. And then there was one other, does express consent have to have a written signature? No, it doesn't have to have a written signature. You can send the person over to a page that says, please send me information on the following 3 things, or that says, yes, I want to receive information from you with respect to all travel deals that you're offering, and put a check in the box. It's that active step that is required, not a signature. Having said that, could you get a signature if someone was in your office? Absolutely. They could put a check in the box and put their signature and the date underneath it. What happens if you change companies? Do you have to get express consent all over again? Well, that depends how you've been operating. If you've been operating and seeking express consent to send all the information to the people that you've got it from ABC Co., then you may have to do that. If you've been getting it for yourself, then you may not need to do that.
Yeah, go ahead. Bottom line on that question is whether you're an employee of ABC soliciting consent on behalf of ABC, or whether you are an independent contractor or outside sales agent connected to ABC, in which case you could potentially contend that you're seeking that consent on behalf of yourself, and therefore it would move with you when you go across the street to XYZ.
Okay. All right. Let's just deal with that last question. Examples of proof of consent. For example, if I get an email, yes, you can print that email, you can save it, you could put it in the text of a document. Those are all valid ways. The bottom line is you need to be able to prove that Tim Law consented to receipt of information about ski vacations in southwestern Ontario, of which there are probably 2, and you've got to be able to prove that I gave that to you. And if you want to do that by simply printing my email, chances are you'll have to print the email you sent to me, because if all I've said is I consent, you won't be able to prove what it is I consented to, but that would be a perfectly acceptable way of keeping it. All right, let's try and stay on time. We'll carry on what it is you need to do in order to ensure you've got what you need. In short, all required information is included with any of these requests that you send for consent. We're back on the contact details, we're back on the mechanisms that have to be in it. The unsubscribe mechanism has to be CASL compliant, has to be easy to use, and you have to give effect to my withdrawal of consent within 10 business days. Email clients who have made an inquiry or purchase before the magical date of July the 1st to ensure that they are eligible for the implied consent grandfathering. That's the 3 years that we told you could get if you managed to do it before July 1st. Always try and obtain express consent whenever you have a new relationship, because you've got the person's attention and you can get them, whether they're in your office or actively involved, to tell you this is what I want to be able to receive from you. Prepare and disseminate guidelines on how certain types of categories of messages should be treated. Those are the ones that are going out in your organization to make sure there's some consistency. And then what you need to do is check around in those email messages to make sure that you haven't said something that you shouldn't. And if you have made it a CEM, just be aware of that, so that when you send out your email not meaning to be a CEM, that it doesn't turn into one simply because of what you've written in the signature line.
The Merry Christmas example.
Yes, yes. If all, we've been asked, well, what if all I'm doing is wishing someone a Merry Christmas or a Happy Birthday? That's a wonderful idea. However, you don't want that simple message, sending good wishes, to turn into a CEM because your tagline or your signature says, always call me first, I'll find you cheaper travel. Signed, Tim Law of ABC Travel. The simple happy birthday wish suddenly becomes a CEM. You don't want that to be the case. How are we doing? We've got a few minutes, so we can get through those. Let's just check a couple of these questions.
And while Tim is checking the questions, let me give to the practical implications slide. I'd mentioned earlier that there are penalties from government enforcement and AMPs, which is the administrative monetary penalties, which are basically fines. They're very stiff. They're very big amounts of money that are referred to, not necessarily in every case that those maximums are going to be imposed, but you're playing with fire if you do violate CASL and find yourself targeted. You do have a due diligence defense. You can always try to establish anyways, that you did your reasonable best to avoid violation, and the fact that you did inadvertently violate should give you a bit of lenience. I'd also mention the class actions that kick in on July the 1st, the private right of action that kicks in on July the 1st, and when it's combined with class actions, it could be a significant amount of money that you're facing by way of private action against you as opposed to governmental action from those three regulatory bodies. There's an impact upon your sale of an agency as well. When we're acting on the purchase or the sale of an agency, the vendor is always asked to make a variety of representations, saying these are the facts, these are true. When Castle comes in, any sort of a business, whether it's a travel business or otherwise, that's going to be bought or sold, I suspect is going to require the vendor to make an assertion that certain things are factually accurate. And Castle compliance is going to be added to that list. If I'm acting for the purchaser of a travel agency and the vendor isn't able to say in the agreement, yes, we've complied with Castle, then I'm going to be telling my client, the purchaser, that he should be reducing the price on offer because he's buying a risk. Turning around to the other side of the table, if I'm acting for a vendor now, or a potential vendor now, I'm going to say get on the horse of Castle compliance and be in a position when you do decide to sell your agency in a year or 2 years or 10 years, be in a position where you can say, yes, we have complied with Castle, because you can be certain that a purchaser's lawyer is going to be asking for that. There are international implications to all of this. Tim at the outset had talked about how if the server, the sender or the recipient is in Canada, then Castle applies. Because of that, there are international implications. You can't avoid Castle by just going to the States and sending CEMs into Canada and blanketing the travel industry, because that tripartite memorandum of understanding that I mentioned among the Privacy Commissioner, the Competition Bureau, and the CRTC talks about how those three regulatory bodies in Canada will cooperate with similar institutions in other jurisdictions. If they come to us and say, Canadian authorities help us to enforce our anti-spam legislation, the three Canadian regulators have vowed to assist. And conversely, if they want to go to their counterparts in other jurisdictions, they're going to be expecting cooperation from them. And the last bullet talks about Canadian versus U.S. law. This is included because the Americans have an anti-spam law as well, but everything that I've read indicates that Canadian is far more rigid with a far higher bar. So if you're reading an American author opining on anti-spam legislation, he or she is probably referring to a lower bar than what you're going to have to meet here in Canada.
All right, let's take the last 2 minutes to answer these last few questions, and then we can wrap up. How do you prove verbal consent? There are various ways you could. You could ask the person to come into your office and record them saying that. That's going to obviously be very difficult. The suggestion that we make is that you make a note of it when you're speaking to the person over the phone. You make sure that you indicate in your notes, I explained that I wanted to send them information about the following travel deals. They said yes, this is the date, this is the email address, this is the name. We also suggest, however, since you've now got their consent, send them an email and say, hi Jane, I just wanted to confirm that I have your consent to send you the following information. That's the best way to get verbal consent, because you're not realistically going to start recording people or having third parties coming in and putting taps on your phones to do so. Wouldn't the subject line be enough? No, that is not enough. I suggest to you that you need to make it more clear than that to what it is the person is opting into. Can you send clients holiday wishes? Yes, I think we answered that. How would the government handle emails sent from multinationals? This is the piece that we both have spoken about a little bit, and that is that if you are sending a CEM to a Canadian computer system, and that's defined as one that's situated in Canada, you have to comply. So the government, I suspect, will hold them to a very high standard that you will not simply be allowed to start sending like crazy into known Canadian email addresses. Will this affect companies in the USA sending emails to Canadians? Yes, it very definitely will, for exactly that reason. It's 2 o'clock, but Joanne is typing. And so we will count to 10, and if Joanne can type that question in the space of 8, 7, 6, I'm joking, Joanne, 5, 4, we'd love to answer your question, Joanne. Come on, don't stop. We'd love to finish by answering your question. We're not going to answer any others, but we are going to wait for Joanne. And she's now gone away. No, she hasn't. Good grief, Joanne. I don't think we're going to have the time in the rest of the day to answer this question. It looks like a long one. And then there was silence. Unfortunately, I didn't bring my harmonica, or I would fill in this embarrassing silence with a tune. Independent travel consultant. Should the corporation be responsible for the agent? You confused me. Here's what I would suggest, Joanne. You take responsibility. You take responsibility for making sure that any email that goes out from your email address is compliant with this legislation. That way, you will be all right, regardless of what the head office does. Thank you, everybody. It's always a pleasure for us to be with you.